Okay, so good morning, everybody, and thank you for joining us for our EMS Legal Services Missouri 2026 legislative update. Um, Today, we want to walk through some of the changes that are coming in Missouri law, most of which will be effective on August 28th of this year if the governor signs it. But for those of you who watched my presentations in the past, I always like to start with a picture of somebody in my family, one of my kids or my wife or dad, because they are all obviously very special to me. And this was a fun picture a couple weeks ago. I had the opportunity to teach the EMS administrator course in person. We did an online one through the spring, and then we did an in-person session in Columbia with Mr. Scott Moore, who is an attorney, a partner at WMK Law Group. He is out of Boston, Massachusetts, and probably the national legal expert for human relations law, especially as it applies to EMS. And so Scott, like myself, is an EMT, and he flew in to teach with us. And my daughter, Gracie, who has always wanted to be a teacher, came and sat in with us a couple days, and Scott let her teach with him. And so she got to run the clicker during the presentations, and she had a lot of fun. There was a moment where she even convinced Scott to get down on the floor and do the sea lion. And I'm not going to describe that, but if you're not familiar with what the sea lion is, you should go and Google it. And I want to give Scott many kudos and props for being willing to follow my daughter's direction and try to do the sea lion. So that's my photo for this morning. This morning, we do want to look at the legislative changes. But before we do that, I want to point out that all of these bills we're going to talk about this morning have been truly agreed and finally passed, which means they've passed both houses of the Missouri General Assembly. And so they've been approved by our legislators, but they have not yet been signed off by the governor. And so they're all pending Governor Kehoe's signature. The deadline for that signature is July 15th. And so oftentimes in the first part of July, we'll see kind of a flurry of bill signings. But that still has to happen in order, or we have to get past that point for these to know for sure that these are going to become law. If they are signed into law, or if the governor does not sign them, they will go into effect on August 28th, 2026. That is the standard effective date for all legislation in Missouri. And so while it is possible for us to have an earlier effective date, none of the bills we're going to talk about this morning have an emergency clause that would make that effective earlier. So I anticipate this morning's webinar will be about 35 minutes, so hopefully a little bit shorter, hopefully some time for questions, and we'll go through that. So we're going to cover what really affects ambulance districts, and then also talk about a pretty important change for 911 centers. And then also look at some of the bills that did not make it across the finish line this year that we may be watching in the future. So let's just kind of, I've got a little overview. In the Missouri General Assembly this year, which began on January 7th and concluded on May 15th, there were 3,150 bills that were filed. Out of those, depending on whether you look at the Missouri Press Association or the Missouri Bar Association, they don't agree on how many passed. It looks like right at 100. So the Missouri Bar says 99 and the Missouri Press Association says 101. And I'm not sure what other two bills they're counting, but they're not important for us this morning. So right at 100 bills out of that 3,150 made it through the process. As I said, of course, all of those bills either have a deadline for the governor to sign or veto it of July 15th. But I want to point out that in the state of Missouri, unlike in the federal government, where we have what's called a pocket veto, and so if the president does not sign a bill, it's considered vetoed. That's not the law in Missouri. If Governor Kehoe does not sign one of these bills, then it becomes law without his signature. He has to affirmatively veto it in order to keep it from becoming a bill or becoming law. And so these bills will become law on August 28th, 2026. that passed both the Missouri House of Representatives and the Missouri Senate in substantially the same form. And so that's what it means when we say they're truly agreed and finally passed. That's kind of our fancy terminology that the Missouri General Assembly uses. If Governor Kehoe does veto something, the veto session begins on September 16th. And so it's certainly possible that the General Assembly could override his veto. I say it's possible. I think it's probably unlikely because, as you may be aware, both our Missouri Senate and our Missouri House of Representatives are controlled by a supermajority of the same party, who is the same party that Governor Kehoe is a part of. And so I think it's probably unlikely that they're going to bite each other's fingers during the veto session and override Governor Kehoe. But it is a possibility. So this morning, there are just several bills we want to look at. There's a new process for ambulance district consolidation that I want to spend a little bit of time talking about. Probably for ambulance districts, one of the key changes just in the process and the way that ambulance districts can merge or consolidate, come together and form one new district. There is a new statutory definition. So the first time we've had a clear definition in Chapter 190 of what it means to be a community paramedic. And so we want to take a look at that. For our 911 partners, some really exciting news. There's the adoption of the Missouri Geospatial Advisory Council, or the Missouri GIS Council. Going to be really important for next generation 911 going forward because it will allow that council to help coordinate some standardization for data and for information for that geospatial database. At kind of the last minute in the session, we had a legislator who slipped in some language to expand the scope of practice for both AEMTs and paramedics. So for those of us who have been waiting for several years for the regulations to make their way through the regulatory process, this change in statutory law, I think, is a little bit exciting because we've essentially jumped ahead and we no longer have to wait on the regulations. And then I do want to point out there's a process to allow ambulance districts now in certain situations to eliminate their subdistricts and to have all at-large members of the board of directors. And so I know sometimes we have some small districts that could be helpful for. So we'll talk about that a little bit. Some of the things that didn't cross the finish line that failed during the session, peer review actually made it further than it ever has before, but didn't quite make it to the end. Again, kind of in the middle of the session, there was a bill introduced that would expand the right for arbitration for public unions and expand those public unions for police, fire, EMS, and 911. And so we want to look at that a little bit. And then there remains a sunset provision in the line of duty death benefit for public safety officers. And so there was a bill that was passed to eliminate that, not passed, that was filed to eliminate that, but didn't quite make it this year. So the good news is that sunset doesn't come for several more years. So hopefully we can get it passed in the future. So let's look then at this ambulance district consolidation process. And I just kind of want to go over the way the old process was. And so as you may or may not know, in 2025, beginning in 24 and then in 25, it continued full speed. Two ambulance districts in Northwest Missouri in Harrison County, Reverend Noel T. Adams Ambulance District and North Harrison County Ambulance District, voted to consolidate. And so they were actually the first districts since the creation of ambulance districts in 1974 to go through this consolidation process. And so as part of that, we learned a few things. And so now we're hoping that we can make some changes in the law that will make that a little bit better for districts that want to pursue that, because certainly there can be some benefits to consolidation, and being able to save some resources and eliminate redundancies. But the prior statute really didn't have a very good process in place. There was no pre-planning required for the consolidation. Essentially, it was simply put up to the voters, and this was the statutory process that was in place. It was presented to the voters. They voted to consolidate. Then the county commission orders another election. And so they actually voted to consolidate in November of 2024. And then in April of 2025, there was an election for the 6 board members. And so then you have 6 new board members, and the law required, and I guess the law still does require until August 28th, required that those existing ambulance districts would cease to exist after 30 days, which of course is a very quick turnaround when we're talking about that new ambulance district being able to get a ground service ambulance license, being able to get approved through CMS for billing Medicare and Medicaid, BNDD licenses, getting everything set up for a new ambulance district, just a very short time frame in that 30 days. And so we had some challenges there that we needed to overcome. As a result of that, the Missouri Ambulance Association, together with the Missouri Emergency Medical Services Association and the Ambulance District Association of Missouri, worked on a bill that was originally filed by Senator Black as Senate Bill 975, that would revise that process in Chapter 190, Section 090. And so the new ambulance district consolidation law will allow 2 different possible ways to begin the consolidation process. And so and this is the same that was in the prior law. There's the possibility for a voter-initiated petition, which requires the number of signatures equal to 10% that voted in the last governor's election. And so you can have a petition of voters that come together. They sign this petition and then present it to the county commission saying, hey, we want to consolidate with this neighboring district. You have to have a similar petition from the voters in that district as well. So it has to come from both districts, either way, whether it's through the voter initiated petition or the boards. Each of the boards can pass a resolution saying, hey, we want to ask the county commission to put this on the ballot so that we can ask our voters to consolidate. However, one of the biggest, I think, improvements in this new law is that these, whether it's the consolidation resolution or the voter initiated petition, there has to be a consolidation plan, which really details out many of the things that will happen as part of that consolidation. So there has to be, that consolidation plan has to include a detailed description of what the new district will look like, including the name of the new district, a legal description of its boundaries, and what tax that new district will impose. It has to include a list of all assets, property, and debts from those districts that will be consolidating, because of course that will all become the assets, property, and debts of the new district. If there's going to be, and certainly there probably should be, a single district that's going to maintain operations during the transition period, that has to be identified in the consolidation plan. There is a presumption in the law, but it is a presumption, so it's something that the consolidation plan can change, but there is a presumption in the law that the district with the highest budget from the prior year will be the one that will maintain operations, but it doesn't have to be. The consolidation plan can designate a different district to do that, but we have to have somebody who's going to continue ambulance service during the consolidation process. The consolidation plan also has to identify the number of board members for the new district, which does not have to be 6 or 5 or 7. You could have 8 or 10 or 12 board members for the consolidated district. There's no limit on that. And it should identify the individuals who will be on the consolidated board, so that once that consolidation vote has taken place, we don't have to wait for another election to elect new board members. And so there is a requirement that at least one member of each of the existing districts will be on the new consolidated board. And then finally, you're supposed to have a proposed timeline, and there's a 180-day maximum on that. So basically that consolidation then has to happen within 6 months. There is kind of a backup provision elsewhere in the statute that says if for some reason we can't make it or finalize it within 6 months, it's not a hard deadline, but the proposed timeline should be within that 6-month period. After both boards have passed that resolution, or the petition has been submitted to the county commission, there is a process for public notice and a public hearing about the consolidation. And that should be a joint public hearing that's held somewhere in the consolidated district. It has to be published in the newspaper, and citizens can come and listen to the benefits of why these districts believe that they should consolidate, how it will help citizens, how it will improve medical care in the consolidated district. And it also gives citizens the opportunity to present objections. After that public hearing, there is a 30-day period where citizens can file written objections. Those written objections have to be signed by 5% of the number of voters in the last governor's election. And if written objections are filed, then the question goes for a vote. But it's important to note here that if there are no written objections filed, the county commission can simply order the consolidation completed. So if you have the resolution of the petition, you go through the process, you have the public hearing, and there are no written objections filed. So they have to be written objections. You can't have your one or two random people who show up and complain at the public hearing. They have to go out and get those written objections with 5% of the signatures. Otherwise, the commission just goes ahead and orders the consolidation. And so, but if there are the written objections filed, then it goes up for a vote of the people. And it then is approved simply by a majority vote of the votes from the district to be, or the consolidated district. So both of the districts, and I say both because it's probably most common that we're just consolidating two districts, but that's certainly not limited. We could be consolidating 3 or 4 districts at the same time, just more complicated, but it is allowed by the law. As far as the tax rate, the law presumes that we're going to use the lowest tax rate of the combining districts unless it's going to be approved by the voters. So let's say we have one district that has a half-cent tax rate, half-cent sales tax, another district that has a 1-cent sales tax. They want to merge together. Well, they're going to be limited to that half-cent if they don't go for a vote. But if there are objections and they go for a vote, or even if there are not objections and they just say, we want to consolidate, but we want the 1% tax rate, then that's going to have to be done by a vote, because of course we can't subject people to a vote or to a tax that they haven't previously approved. And so we'd go with the lowest tax rate by default. I want to really stress this new law doesn't allow for any provision for a hostile takeover, because I've heard some concerns about that. There's no possibility for forced consolidation of ambulance districts here. The Bureau can't come in and say, oh, we want these 2 districts to consolidate, or some outside entity can't come in. It has to begin either with the boards of each of the ambulance districts or with a voter-initiated petition. Now, that's not to say that it can't proceed even if there are people who are not happy, right? Because we can have the written objections and then it goes to a majority vote. But there's nothing in the law, in this new law, that allows anybody to come in and forcibly take over your district without support from within your district, if that makes sense. So I just want to assuage some fears there. So moving on, in House Bill 2372, we actually kind of achieved a big win here, because we established the first really clear statutory definition of community paramedicine in Chapter 190. And so we amend Section 190.098 to provide this definition for community paramedicine that really focuses on non-emergent settings, right? And so community paramedics are not the ones who respond to 911 calls. They're not going out there and checking on people who are calling 911. They are providing primary integrated healthcare in their communities. And so that's always based on the medical director's protocols and the primary care physician's patient plans. But so we've established the statutory definition that makes them very distinct from traditional 911 emergency response. However, we envision that these community paramedics will still be part of an ambulance service. And so still the Bureau is going to be adopting some regulations for recognizing community paramedic services. and issuing an endorsement to the ground service ambulance license that operates those community paramedics. And that ground service endorsement will be for a 5-year period, according to the statute. The law does say that if you are an ambulance service that is entering into the area, the service area of another ambulance service, you have to have a written contract to provide community paramedic services in the area of another ambulance service. But I want to point out that community paramedic services can be provided by other entities, right? They may not be defined within this scope as community paramedic services, but you can have a hospital that's sending somebody out to do this primary care. This statute applies only to ambulance services, so ground service ambulances that are regulated by the Bureau. This would not prevent a hospital from sending people across into your service area because they're just not subject to this statute. So the law really focuses on ground service ambulances. So for our 911 partners, Senate Bill 959 was a pretty big win here because for several years they have been working on creating the Missouri Geospatial Advisory Council. And this bill does exactly that. So we create the new section 37.1310, which establishes the Missouri GIS Council within the Office of Administration. And for our 911 friends, this is really a pretty big deal. Because the bill specifically identifies Next Generation 911 as the primary life-saving entity that statewide GIS data infrastructure should be focused on serving. And so for those of you who are not maybe as familiar with GIS, that's our mapping database, all of the addressing, the locations, coordinates, basically all of that data that lets us pinpoint where people are, right? And so that matters a great deal to Next Generation 911 because we route our 911 calls based on GIS data. And so if that data is wrong, then the call gets misrouted and we have a mess in the telecommunications center and we have a mess for those of us in the field. So this really sets up the Missouri GIS Council to help standardize that data across jurisdictions, which is important as well because like ambulance districts, we have 911 districts that are local districts. And so there can be a significant variance in the way they do things from one jurisdiction to another. So this council, I think, will help us standardize that data to really improve the GIS information all across our state, which, as I said, is just really important for our Next Generation 911 readiness. There is the opportunity to apply for some federal grants to fund infrastructure approvals. But for the PSAPs or the public safety answering points that are working toward Next Generation 911, the establishment of this council, I think, will really help us continue to move that forward. For AEMTs and paramedics who maybe have been waiting a long time to see their scope of practice expanded, we have some exciting news. Again, in House Bill 2372, there is now going to be a change to Section 190.142 that will provide that both AEMTs and paramedics going forward will use the current national model for the scope of practice. And so my assumption is that even as the national model continues to change, so too will our state scope of practice without requiring additional regulations, because the statute says we're going to use the current national model. It doesn't say we're going to use the 2017 model or the 2019 model. It says we're going to use the current model. And so my assumption would be that as new models are adopted for AEMTs and paramedics, that will just continue to expand and Missouri will track with the national model going forward. For AEMTs, of course, that includes the ability to administer medications, including analgesics, antiemetics, cardiac epinephrine, supraglottic airways, and IV therapy, all really great things that AEMTs will now be able to do. Again, this will be effective September 28th, as long as the governor doesn't veto it. For paramedics, of course, they will track the national model as well. But there is, in addition to that national scope of practice model, there is the possibility for some additional expansion. And so the law will provide for the state EMS Medical Director Advisory Committee to add to the scope of practice for AEMTs. And so that Medical Director Advisory Committee is part of the state advisory committee. They can make a recommendation through that committee to add to the scope of practice. And in doing so, that will expand the scope of practice for AEMTs. That has to go through that state committee for AEMTs. For paramedics, it's different. The law provides that your local medical director will be able to add to the scope of practice for your agency or for an individual clinician. And so your local medical director for paramedics could expand the scope of practice for paramedics beyond that national model for your agency. Your local medical director could also do it just for specific clinicians. So lots and lots of flexibility for your local medical director and our paramedics to expand that scope of practice in the future. Senate Bill 975 also made some revisions to our ambulance district sub-districts, just allowing the possibility for our ambulance districts to convert to at-large members rather than our 6 members from individual sub-districts. In order to do that, and so we've had some issues in the past with smaller districts not being able to find candidates to run for the board. That's actually one of the qualifications to be able to use this change. And so if a ambulance district wants to eliminate its sub-districts and just have at-large board members, they have to have a public hearing about that. And then there has to be a 2/3 vote on an ordinance, which would eliminate those sub-districts. If the district adopts that ordinance, then all the existing members become at-large directors. And so they just continue to get reelected on the same cycle, but rather than being limited to coming from within their specific election sub-district, they could be within anywhere in the ambulance district. And then if we have a district that maybe gets rid of their sub-districts and wants to go back, they can certainly reestablish those election sub-districts again by a 2/3 vote. And so just the possible change to get rid of the sub-districts if your agency is one that struggles with finding folks to run. Deanna, did you have a question?
No, I'm very interested in this though, because this sounds like a good deal for our area because we do struggle with that.
I think especially for some of the smaller areas, this will be very helpful. I know that there are also districts where we didn't necessarily want to make that mandatory and get rid of it for everybody. Because the sub-districts certainly do ensure that all areas of our district have representation, right? So they don't all come from one area. So just a possibility out there that we now have.
So, and this has to be done with like a public hearing. You just put it out there and say, hey, we're going to have this hearing and this is what we're going to vote on.
Yep. Yeah. So there would be a public hearing, and then it has to be approved by 2/3 vote of your board rather than a simple majority. But certainly if that's a path you want to explore, I'm happy to work out those details with you and help you with the notice and the ordinance and all that. So.
Yeah, I'd like to talk about that. So that'd be awesome.
Okay. So I just want to shift a little bit now and focus on some of the legislation that didn't cross our finish line. And so we want to look at our peer review protection that many in our community have been working diligently for 25 years, probably trying to get peer review protection for EMS. Of course, peer review protection is that ability to participate in those quality review discussions with our physicians and our hospital staff about what went wrong or what we could have done better. Really some great ways to work on quality improvement. Unfortunately, at the moment, EMS is not included within the scope of our peer review statute, and has not been because the peer review statute predates the establishment of EMS. And so if we participate in those quality review discussions, then there's the possibility that that would be subject to discovery in a criminal process, or not in a civil process. I apologize, not criminal. But our state protection for those quality review discussions is simply not protected by state law. The bill made it further this year than it ever has. It passed the House, you can see by a significant majority, but didn't make it through the Senate. So hopefully in 2007, they will try again, and we'll continue to make progress on that. However, I do want to point out for those of you who are not already involved in the Center for Patient Safety, that is the federal patient safety law that will protect these discussions. And so please, if you're not already a member of the Center for Patient Safety or another PSO, please look into that because it helps protect our quality review process under federal law. And so while we will continue to work on making these revisions in state law, we do have some federal protections out there. If you have any questions, please don't hesitate to reach out and let me know. House Bill 1644 would have kind of expanded the wage and benefit discussion for unions for fire and EMS. Specifically, there were some proposed revisions to Missouri's public sector labor law that would have really changed maybe some of the bargaining rights for emergency service unions. Most importantly, I think the bill would have created a new statutory framework specific for first responders, including firefighters, EMTs, 911 dispatchers, police dispatchers, and it actually moves police officers from another area into the statute in with first responders. And so it would allow for a union to be designated as the exclusive bargaining representative for the employees. And that would then negotiate with the public employer, our districts, about things like wages, benefits, and other terms and conditions of employment. I want to point out that I think, and as I said, this was kind of introduced in the middle of the session, so it was the first time this bill popped up, but it technically included only EMTs, which I think was probably an oversight on the part of the drafters, because I would assume that if we were going to have unions, we'd want to include paramedics within that possibility, and so that may be a change that they work on in the future. But this bill actually only mentioned EMTs, and so we know we have other folks in EMS beyond EMTs. And so, but the bill would have required that if the parties weren't able to reach an agreement within 180 days, it would have gone to mediation and then on to binding arbitration, which would be a pretty significant shift from Missouri's current framework, because currently public employers have to bargain in good faith, but they're usually not forced to accept terms through arbitration. And so if you're not familiar with arbitration, arbitration is essentially like a mini court process. It's less formal than the courtroom, but in the end, the decision of the arbiter is very similar to the decision of a judge. Because whereas in mediation, both sides have to come to an agreement, in arbitration, the arbiter makes a decision and everybody is bound by that. And so certainly a bill we want to keep an eye on in the future, because this would just definitely have some impact in emergency services, as our union partners are involved in discussions about wages and benefits. So something to keep in mind in 2007 or 2027, I'm sorry. Finally, the last major piece of legislation I want to talk about that did not make it across the finish line was this attempt to remove the sunset provision for the line of duty death compensation benefit. And so currently there's a line of duty death compensation for public safety officers, excluding 911 telecommunicators, that if they die in the line of duty, they will receive $100,000. That's actually an increase. Last year, we were successful in increasing it from 25,000 up to 100,000 for those public safety officers that are killed in the line of duty. This current program sunsets or expires on December 31st, 2031. And so this bill would have eliminated the sunset provision. As I said, it didn't make it very far this year. I don't know that it even really got out of committee. That the benefit does cover EMS, fire, and law enforcement. However, it does not reach to include our 911 telecommunicators. And so maybe certainly something we can discuss in the future as we work on getting rid of that expiration date. Also having our 911 telecommunicator first responders covered by this bill as well. It doesn't cover everybody who dies as a public safety officer. It only covers those who lose their life in the service of performing their function as a public safety officer. So hopefully something we can continue to work on in the future. So that is it. I think we've covered everything that I wanted to cover, and I think I stayed pretty close to 35 minutes, like was my goal. But if you have any questions, I'm happy to do some questions or additional discussion. I will go ahead and stop sharing my screen. I do want to encourage you, though, if there is a law or something that you think, hey, we should really change this. Discussions about legislation don't start in January when the session opens. They start in the late summer and fall. And so coming up here very quickly, we will begin discussion about what it is we want our legislative priorities to be in 2027 as an EMS community. And so if you have any changes that you would like to see or revisions to the law, something you think, hey, this would help us make EMS or 911 better in our state, please don't hesitate to reach out to me. You can reach out to Jason White, also is heavily involved in that. Any of our statewide organizations, so Matt Bowen at the, or Barb Shoup with the Missouri Ambulance Association, Roy Pennington or Kat Probst with the Ambulance District Association of Missouri, and then, of course, the Missouri Emergency Medical Services Association. Shelby Cox is our executive director, and Justin Duncan is the president. So definitely reach out to any of those folks and share your ideas. We'd love to have suggestions about how we can improve the law for EMS and 911. So does anybody have any questions or any comments or thoughts about this morning's discussion? I tell you what, I'm going to stop the recording so that way you can ask questions and not be recorded in case you don't want anybody to know that. So.